Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Good news out of Washington State, and this is an important case that happened. Dave, thanks for sending me the link on this one. But it used to be that if you got arrested for suspicion of drunk driving, they would just impound your car as a matter of course, regardless of whether there was somebody with you who could drive the car, regardless whether your car was on private property, regardless of whether your car was legally parked. They would just impound your car and, in essence, punish you, number one, before you've been found guilty of anything, but number two, adding cost to the transaction is unnecessary. But they had a law on the books that said that. So the Washington Supreme Court strikes down mandatory car impounds on DUI arrests. This is from the spokesman, a Washington newspaper. Jim Camden wrote the article. Automatically impounding a vehicle whenever someone is arrested for driving under the influence is unconstitutional. A unanimous state Supreme Court ruled. The mandatory seizure law was passed in 2011, and according to the court, it violates a person's constitutional right not to be disturbed in his private affairs or his home invaded without authority of law. The court said if the car is safely off the road or someone else is available to drive the car away, police should get a warrant to impound the car. Otherwise, if they have no business getting a warrant, they should let someone else drive the car away or leave it parked safely off the road. Justice Stephen Gonzalez wrote, "Our Constitution cannot be amended by statute. The legislature can give more protections to constitutional rights, but it can't pass laws to take those protections away." The court overturned the seizure of drugs and paraphernalia in a Grant County case that stemmed from a car impounded after the driver was stopped for speeding but arrested for DUI when he refused a field sobriety test. The search of the car turned up small plastic bags, digital scales, $340 in cash, and other items the officers believed were connected to drug dealing. The officers searched the vehicle and discovered cocaine. They just searched the driver and discovered cocaine. The driver was then charged with DUI and possession with intent to deliver drugs. The driver asked the trial court to suppress the evidence because the only grounds for the search was the mandatory impound. And, they impound a vehicle, they do an inventory of it to make sure that they can keep track of what's in it before it all gets stolen and disappears. Other passengers could have driven it home, he argued, and the cost of retrieving the car from the impound could be more than $1,000, which sometimes results in a driver losing the vehicle. That's another problem altogether. The trial court agreed, and that ruling went straight to the state Supreme Court while the trial was put on hold. The Washington State Patrol weighed in on the side of the prosecutor, of course, while the American Civil Liberties Union and other groups sided with the defense. The mandatory impound law passed both houses of the legislature unanimously after people were seriously injured, and the state was required to pay more than $1 million in a lawsuit involving what they said was a tragic accident. A woman who was arrested for DUI and taken home then took a cab back to her car while still intoxicated, drove it again, and hit an oncoming car. But the point is, the mistake there was not leaving her car by the side of the road. The mistake there was letting her go while she was still intoxicated. I've never heard of that. I have heard of police arresting people who are drunk and making them blow a breathalyzer before they can leave. You don't let someone who's been arrested for drunk driving walk out of jail drunk. The statute is sometimes called Haley's Law after the name of a victim of the crash. And it requires the cars to be towed from the scene and kept in a storage facility for at least 12 hours, unless another registered owner comes to retrieve it. But of course, that involves the impound, the inventory, and the costs of doing all this. Court said that's too broad, and the court's making a point there, which I should probably explain. Legislatures can pass laws, and they are often reviewed by courts to see if they're constitutional. And it's not uncommon that a legislature will pass a statute and say, look, we've got a really good reason for the statute, such as keeping drunk drivers off the road. And they'll say, we passed this law to do that. And the court will say, well, you had a good reason to pass a law, but you could have done the same thing with a narrower law. Okay? And so if your statute is too broad, the implication is, well, yeah, it does have a good constitutional purpose, but it's going to have some bad unconstitutional results. And one of those, for instance, is, let's suppose I'm driving with somebody who is sober as a church mouse and I'm drunk as a skunk. Skunks get a bad name simply because their name rhymes with drunk. And so I get arrested for drunk driving, but my passenger who has a driver's license is not allowed to drive the car away. Now, why would that be? And you can't say, well, it's to keep me from getting back in the car, because why can't the police just hold me till I sober up? That's the obvious solution to this. And, I understand, I'm not defending drunk drivers. I think drunk drivers, when they get pulled over, need to be arrested and they need to be held, and they should not be released until they're sober. That's number one. And then they should be prosecuted and so on. I'm all in favor of getting drunk drivers off the road. I'm 100% in favor of that. But to say, and we automatically impound their car and make them run up another $1,000 in impound fees just because we can and nobody likes drunk drivers, well, that's wrong. Okay, so the laws have got to be narrowly tailored to get the result they need. And this law, according to the Supreme Court of Washington, was too broad, and I agree. Under the Constitution, an officer must consider alternatives, such as whether another person is available to drive, or whether towing the car is necessary to protect the community. Without those exceptions, the officer would need a warrant to impound the car. There is no probable cause to seize the vehicle, the court wrote. The trial can continue, but without the items found in the search of the vehicle, and good luck with that. So, Washington's Supreme Court has struck down their mandatory car impound and the DUI arrests, and I agree with that. Again, like I said, I'm not sympathizing with the drunk drivers. And, if it's in a place that causes a problem, yeah, tow it. But I mean, I've driven up and down the highway, and I've seen a vehicle by the side of the road that's there one day, and next day I drive by and there's a sticker on the window indicating that somebody came by and said, this car will get towed if it's not removed in a couple days. And I think they give them 48 hours. Well, why can that car sit there for 48 hours, but the person who's arrested for drunk driving, their car can't? And again, if you say, well, because they might go back and get into it drunk, not if you sit on them until they're sober. I mean, that's simple. That's simple. So don't pass a law that's overly harsh and say it's okay because we're just punishing drunk drivers. No, it's not how it works. So the laws have got to be fair. They've got to uphold the Constitution. In this case, you're talking about the state of Washington's Constitution, not the U.S. Constitution. But that's an interesting question, how that would have happened if that had gone up on those grounds, but it didn't. So there you go. Again, Dave, thanks for the story. Washington Supreme Court strikes down mandatory car impounds on DUI arrests, and the story is written by Jim Camden. Questions, comments, put them below. Let's talk to you later. Bye-bye.